Natalie, is there anything that we need to do at the start of this? Is there anything that we need to have read?
No, not really. I mean, I think it would be helpful just to mention that, just say your name before you speak each time.
Okay, will do. I'm John Francis. I'm chair of the Subcommittee on Consolidation and Supervision. This is our monthly meeting. We are meeting by video conference through WebEx. It's also my understanding that there is a location in the State House where members of the public can attend as well. And I'm going to ask everybody who's present to go ahead and note their appearances. And Secretary Zamuda, since you are next on my screen, I'm going to ask if you could go ahead and introduce yourself. Okay, you are muted at the moment, Secretary Zamuda. Okay, well, we'll go ahead and note that Secretary Zamuda is here. And Spence, I'm going to ask if you could go ahead and note your presence next.
Sure, Spence Cohen. I'm the Services Specialist with the Office of Judicial Administration.
Okay, thank you. And Shelley, you're next on my screen.
Good morning. Can you hear me?
I can, yeah.
Okay. Shelley Williams, Director of Riley County Community Corrections and the Community Corrections Representative on this subcommittee.
Okay, thank you very much. And Sheriff Carr, welcome today. I also see Stephanie Durier from Council of State Local Governments is on the call.
Good morning, and nice to be with all of you this morning, or this afternoon, Kansas time.
And thank you for joining us. And Amy Raymond from who is Chief of Trial Court Services at Office of Judicial Administration is also with us. And Amy, thank you for joining us as well. Okay, prior to, and have I noted everybody on here now, I think? Okay, super. I sent or actually Natalie on my behalf sent around an agenda for today's meeting. I've got 5 things on here. I honestly don't think we're going to get to all 5 of these issues during the hour. If we do, that's great. But I definitely want to take up the issue number 1 first, and after that we might take some things out of order. It was brought to my attention in large part by Ms. Raymond that that the name that this subcommittee has been using has, I think, caused concern that the purpose of this subcommittee is to explore consolidation of agencies, and now that it's brought to me, now that issue has been brought to light, I can see why the name might give that impression, but that is not the purpose of this subcommittee. We're really looking at how we can, when we have someone who is under multiple supervision, how we can avoid a situation where that person is being supervised by multiple agencies at once. So the idea here is not to consolidate agencies, but to consolidate supervision that an individual might be receiving. And so based on that, I'm proposing that we change the name of the subcommittee. I'm speculating that Ms. Raymond is not the only person who has had the impression based on the name that we were doing something that is really not the goal of this committee. So I'd like to toss out that idea first. I have no magic in the name I'm going to suggest, and I have no pride in authorship either. But I was kind of toying with some ideas that would hopefully better capture what we're trying to do, and maybe call the committee, and it's a clunky name, but duplication of resources for supervisees in multiple cases. And that's at least something that I'm tossing out, and if folks, and this is to prompt discussion, but if people have a different suggestion, I welcome it.
Well, this is Sheriff Carr. I don't see a problem leaving it as it is. We're coming to the tail end anyway. I mean, those who've been involved in this understands what it's about. I think the final report will speak for itself. So, I mean, we're literally in the end stretch here. So,
Yeah.
just my 2 cents.
Well, I think that's a very good point too. Other thoughts on this?
This is Spence Cohen. Because I knew of what this issue was, and the consolidation, what that means to most people. I've just been calling it, and when I look at my emails, the dual supervision subcommittee. So just a simple name that kind of talks about what we're really dealing with.
Dual Supervision Subcommittee is a much more elegant and direct name than what I came up with. So yeah, I mean, I think that is better and more streamlined. Other folks, I think Sheriff Carr does have a good point that, we are just probably 2 meetings away from our final meeting here, and this might just be, rearranging furniture rather than doing anything significant. But there may be value in just in taking this up to get to that idea of dual supervision.
This is Shelley Williams with Community Corrections, and that has been what I've been calling it in my calendar as well, is dual supervision.
And this is Spence Cohen. Could we maybe just add dual supervision to the name so it's not that big a deal? Consolidation of dual supervision.
I actually just like the idea of just making it dual supervision subcommittee, period. If we're going to do that, I think that would capture the name. And Amy, since you're on the line, do you think that would help clarify some of the concerns that are out there?
I do. This is Amy Raymond with OJA. Can you all hear me?
Yes.
Okay, great. I've not used WebEx before, so I wanted to make sure my microphone was correct. So yes, I do. And I understand that everyone on this committee understands your charge and what you've been talking about. It's just when these meeting notices started coming out, we got lots of questions. And consolidation in general, as some of you know, is a big buzzword, and it has a lot of different layers to it. So I think that just calling it dual supervision subcommittee would resolve that.
All right. So is there a motion to change the name of the subcommittee to dual supervision subcommittee? Okay, got a motion. Do we have a second? All right, we do have a second. Any further discussion? All right, all in favor of changing the name of the subcommittee to dual supervision subcommittee, say aye. Well, actually, no, I think we have to do a voice vote. Sorry. Sorry about that. Okay, Spence.
Aye.
Shelley.
Aye.
Sheriff Carr.
Aye.
Secretary Zamuda.
Not sure I'm off. I'm not sure I've got my mic working yet, though. Is it working?
Yes, it is.
All right, good deal. Aye.
Okay, and Senator Haley. Okay, I don't know if Senator Haley, you're muted at the moment.
I'm trying to unmute.
You're unmuted now. You're good.
Okay, good. Well, thank you. I'm not an official member of the subcommittee. I was really just tuning in to get some legislative review or input, but thank you. I would vote aye. If I had a vote, I'd vote aye.
Well, thank you for noting that you're not a member of the subcommittee. And I also vote aye, so I believe this carries unanimously. All right. The next agenda item that I want to take up actually is what additional data needs to be collected before we can even make any recommendations to the committee itself. And one of the questions that I think has been raised to me is how widespread of an issue is the dual supervision or multiple supervision issue? What's the fiscal a question I would have related to that is, what's the fiscal impact of multiple supervision? How does multiple supervision affect outcomes? And so, I think to be sure that we're not just trying to find a solution in search of a problem, what is the need to address this? We have been talking about some issues, but I don't think we've been talking in really concrete terms about what the need is to address this. And so I open that up for discussion.
John, this is Jeff Zamuda with the Kansas Department of Corrections. When CSG, I think CSG did some looking at this. Did they have some numbers into how often they saw? I thought we had some numbers on how often dual supervision was occurring. Am I remembering that correctly?
Yeah.
Stephanie, can you field that?
Yeah, this is Stephanie with CSG. Secretary Zamuda, you're absolutely right. We had some estimates. So the problem, as I understand it, just to give some context, so I've joined the project this year, so I wasn't a part of it last year. So this is my understanding of it, is that we were only able to actually take a look at dual supervision across community corrections and parole because we did not have access to OJA data. Now, when we look at anecdotal evidence from those who have kind of told us what it's like in their district between court services and community corrections, it goes up to 15%. So we're hovering around the area 5 to 15% of the population, supervision population being on dual supervision. I will say, and I want to make sure I mention this to the committee, and Amy and Spencer are really well aware of this, and so is Shelley. Last week, I started a round of focus groups with chief court service officers across the state. So we got in, I believe, conversations with about 10 or 11 of them so far. We have another round this week going. And I will say, between their estimates, and of course, I put them on the spot, so nothing is going to be 100% accurate in this estimate. They believe that anywhere from 5 to 10 to 12% is their population in their specific districts. And this was the more rural chief court service officers. So we do definitely have a need in the state. When we're talking in some of the numbers that some of these districts are facing, when you get up into the hundreds of people, this is a pretty good amount of people that are on dual supervision. So it definitely was the stance of CSG that this is something the state would benefit from focusing on and finding a resolution to.
Okay, thank you, Stephanie, for giving that context. And yeah, it does sound like 10, 12, 15% is significant. Is there any estimate on kind of the next two questions that I talked about, which is fiscal impact, and also what impact does this have on outcomes for supervisees?
Yeah, this is Stephanie with CSG again. I won't speak specifically to the fiscal impact because I cannot give you hard numbers. That would be definitely more something that KDOC, OJA could provide. So I don't want to speak to that, but I can speak to the fact that whenever you're duplicating efforts, you're duplicating resources. And that's never a good idea, especially in our rural communities. Listening to some of the chief court service officers, they've got 3 folks on staff, 6 counties, an unbelievable amount of square miles to cover there. And so any kind of duplicative efforts, especially if they're not sitting in the same building as their counterpart probation, has proved really challenging. The other thing to consider is that there are some consequences for outcomes, just again, anecdotally, and we have a formal summary that'll be coming to the full commission and obviously the subcommittees in October once all of these focus groups are over. But one of the definite outcomes that I've already heard across multiple districts is that when dual supervision is taking place, there's a really mixed amount of communication happening. So some districts have really great communication between court services and community corrections, where they sit in the same building, or they almost think of each other as coworkers just because there's so few of them and so many of those on supervision. And so they've really created a really good working relationship. In other districts, it's just not the case. Either there's some barriers there to distance, or they don't have as many overlapping supervision cases, and so they haven't built that relationship. It may be that there's been turnover in officers and leadership, and that's just created a barrier itself because you're not familiar with who's working in the offices when there's that kind of turnover. The other thing I would say is when dual supervision is happening, there's been some problems with communicating about conditions between agencies. So for example, if someone moves from court services supervision to community corrections, it's not always the case that community corrections will enforce the fines and fees that court services is not allowed or not willing or allowed to drop. And so what happens is that that person will serve their term with community corrections and then be transferred back to court services where they'll remain on supervision until they can pay off their fines and fees. So they've done the bulk of their supervision time, but now they're continuing on supervision just to pay off those fines and fees because they weren't collected by the second agency. And that's the kind of barrier we want to see resolved so that someone who is on, a concurrent supervision status can actually pay those fines and fees, that whichever agency is doing the supervising can kind of enforce that those fines and fees are being paid. And that's just one example. There's a couple other examples that we could obviously dive into that I'm sure like Shelley and Spence have heard throughout the years. But that's a really good example of how we're extending supervision just because our agencies aren't enforcing conditions, or may not be allowed to enforce conditions across agencies.
Okay, thank you, Stephanie. And I think that also leads into the next point, although I want to open it up to other folks to talk about this point, but that does kind of segue into the next point about benefits of eliminating, multiple supervision scenarios, having a situation where there's a person being supervised really by one agency. So let me open this up to folks to either add to what Stephanie had to say or to comment on what Stephanie said.
Professor Payne, this is Shelley in Manhattan, and I apologize, I didn't recall this with everything that's been going on, but I had requested of the Sentencing Commission some data after our last meeting to see if there was any way that they could run felony court service cases by jurisdiction and fiscal year and cross-tabulate those with community corrections cases in the same jurisdiction and fiscal year. And John Grube, he's in charge of research over there, he thought that was something that they were going to be able to do. He also suggested that we overlap by 6 months of each fiscal year, so that if somebody was sentenced to the two supervision entities that we're talking about in particular, within basically a year's time frame, they could possibly catch that. I didn't follow up with him until just now to see if they had an opportunity to run that data. I know they have their Sentencing Commission retreat this week, and so I'm sure they've been super busy preparing for that. But I did do a follow-up to see if there's any way that they could try and give us some estimation of data.
Okay, thank you, Shelley. And just to clarify, that would find duplication between court services and community corrections, you said?
Correct. And that would just be those that are sentenced to both within a certain time frame, but not necessarily, if they fall outside of those parameters of the dates that they run, but it would at least give us a start, I guess, with the data.
And would that be statewide data or just in your area?
Statewide.
Great. When you get that, could you forward that to the rest of the committee, rest of the subcommittee, rather than waiting till the next meeting? I think that would be really helpful. Thank you. Other comments or additions to this conversation? Okay, then I think this permits us to go back to, well, actually, let's expand a little bit more and go to, what are we perceiving as possible benefits, and I think we've heard a little bit of that, but also what are some potential downsides, if any, to consolidating supervision in a dual supervision type of situation?
This is Sheriff Carr. One thing I could see is just a main point of contact for law enforcement, contact with people on supervision, clarification who's going to be the lead officer, I guess, to contact maybe.
Is that something that could be addressed if there was a mechanism to get word out to law enforcement that, you know, this person is in any given case, that there's a way of identifying who is the point of contact? I mean, is that even a mechanism that could be built into the system?
Oh, absolutely. I mean, we currently have lists of who's on court services and community corrections and juvenile services and state parole, like I said. But if you're going to put this mechanism in place, I foresee it, and Spence and Shelley, obviously, in OJA is, as Amy brings up, now who's going to be in charge. But ours, we provide the list to our communications center. So if an officer's out with somebody, it's on what we call paper, then we just ask communications. So I think it's probably going to be amongst the directors to try to iron that out as to who would be the point of contact for incidents.
And Sheriff Carr, if you could just expand on that a little bit to educate me. When an officer is, you know, making a stop, if they encounter somebody who's on probation or parole, is there something that pops up now that says, you know, this person's on parole and this is their parole officer? Or
if it's entered in the system, yes, but not everybody enters them in the system. So but we've just got kind of muscle memory that in conversations with them on the side of the road, or if we're dispatched to a call or whatever, you just ask them, hey, are you on paper? And most generally they'll tell you yes. But like I said, we run into that 5 to 15% that, yeah, I got this probation officer, I got this parole officer, and so on and so forth. So that would be the only other issue I would truly foresee happening. As then obviously we don't need I guess an argument. Monday rolls around. Now I've got community correction saying, hey, they didn't contact us, but court service saying, hey, they did contact us, or vice versa. So.
okay. And it sounds like even if we don't do anything here, it would be a good idea to improve the way that data gets entered into the system anyway.
Absolutely.
This is Stephanie. Oh, this is Stephanie with CSG. I would definitely love to pull Spence and Shelley into this conversation a little bit, because I think one of the challenges that I've heard to the dual supervision is the differences in the conditions that are being met. And this is also some area where I think that there's really good collaboration with the condition subcommittee that's actually taking place right now, is that there is a feel across the state, or at least in some jurisdictions, that the conditions aren't similar enough, or they aren't enforced in the same ways. And so that's, you know, creating some resistance to kind of combining, or to finding a solution, I should say, excuse me, to dual supervision. So I think that's an area that could definitely be a collaborative effort with the condition subcommittee, talking through what are those standard conditions, what do standard conditions look like in the more rural areas versus more of your big city areas, or across the districts, why they may have some standards that aren't necessarily standards than others. So for example, some districts, judges have determined that they don't want anyone on supervision drinking alcohol or using drugs. That might not be a standard in another district. So figuring out what are those standards, and also figuring out some of those mechanisms of, although community corrections can't collect money for court services, what can be put in place so that some of those conditions of their supervision are being met and maintained for either agency, no matter who's doing the actual supervision. duties.
Thank you, Stephanie. Shelley or Spence, do you want to weigh in on that point?
Sure, I can. This is Shelley. Certainly having a wide variety of different conditions and expectations of supervision is going to be complex for everybody to keep track of, especially the offender and the supervision entity who is overseeing the case. Those are definitely topics that we're going to talk about at our next supervision condition meeting. Another thing that comes to mind that really adds to complexity of having multiple supervision entities, in addition to, you know, someone could have upwards of 100 different conditions that they would need to follow, but would also just reporting multiple times in a month to multiple entities, and that, you know, impacts transportation, employment, and the time that they need to take off from employment to see multiple supervision entities in 1 month is it's a lot to keep track of.
Thank you, Shelley.
And this is Spence Cohen. You know, as I'm thinking about this, as an officer, I'm probably not as concerned about the multiple number of conditions of probation, because, you know, as we look through the conditions of probation, that they're generally all very, very close to similar. You know, some of the words are going to be different, but your main conditions that you're really watching out for are the special conditions. You know, if someone has restitution, if someone has batter's intervention or drug information, you know, I think as an officer, those should be the things that are really picked up on versus, you know, the 30 or 40 conditions that might be transferred. Because I think officers are really good about knowing what people should be doing when they're on probation. That's our jobs, right? So I'm not so concerned about that. I do agree with the dual supervision, that it, you know, the multiple reporting, that can be a hassle, that can be a cumbersome for the person on probation, and hard to make it all work out right, especially if they're trying to hold the job down. So I do see that those are issues for certain, that, you know, combining supervisions can address that. So I'll leave it at that right now.
Okay, thank you, Spence. Secretary Zamuda, do you want to add anything to this?
This is Jeff Zamuda. Oh, can you hear me? Yeah, and you know, I don't think I can. I think I agree with what Shelley was talking about the difficulties for the person under supervision that dual reporting can create. And I think the work of standardizing those conditions to the extent possible will really help not only that person under supervision, but what we're talking about here. If we're all pretty much on the same page on that standardized supervisions, then I really don't think it's going to be that big a difference who ends up supervising them.
Okay, thank you. So kind of distilling out what I'm hearing, it sounds like there's a, you know, not total uniformity, but a general consensus that there is a benefit to avoiding situations where people are being supervised actively by multiple agencies, reporting to multiple people, that this does have a potential negative impact on the ability to hold down employment, that there are transportation issues that are impacted as well. And so for more clarity and better outcomes, and to help people really reintegrate into a productive dynamic, it would help to reduce the number of people they're reporting to. It sounds like there would need to be better communication between agencies, particularly with respect to special conditions. If somebody's on restitution, or somebody's paying restitution, if somebody has a program they're doing, like batter's intervention, or a drug and alcohol program, something like that, there needs to be better communication across agencies with that. And that there is this challenge that there may not be uniformity in standard conditions. That the big stuff is, you know, functionally similar. But as Stephanie pointed out, there are some differences in things like, is no consumption of alcohol going to be a standard condition across agencies, or will there be some variance with that? And so those will be some potential challenges here. But it sounds like there is a consensus that there's value in moving forward with a plan where we could consolidate I want to avoid that word, where we could have people report to one person, have basically one lead agency in a particular situation. So I think that brings us to the next question of the metric or metrics that we would be using. And we have talked about some different things. We've looked at the Ohio statutes, which, if I recall, use severity of sentences as the primary metric. We've talked about using other evaluative metrics. And so I know we've talked about that a little bit, but now that we have, I think, a little more of a sense of some of the benefits, I'd like to revisit that decision or that discussion rather. And so now that we've had some opportunity to think about this, what are some of the most important considerations in determining if somebody's supervised by multiple agencies, which agency should be taking the lead on it if we were to go ahead and do that?
John, this is Jeff Samuto with the Kansas Department of Corrections. I seem to recall what part of the discussion that we had previously was who might have the longer term of probation. Maybe that's a factor. So if community corrections had a 3-year term of probation and maybe court services had 2, perhaps it goes to the agency with the longer term. So there's that continuity, so they don't finish up with one agency and then get passed to another.
Okay, thank you, Secretary Zamuda. I think that point about continuity is a really important one, that they're not being passed back and forth constantly. Other thoughts?
This is Spence Cohen. And just thinking about what Secretary Zamuda just said, if we, I guess it really depends on how we look at doing these transfers. Are we looking at a, kind of what we currently do is a courtesy supervision, where we transfer a case from one agency to another. And then when that supervision ends, then it goes back to the original jurisdiction. Because if we're looking at it that way, whereas say community corrections has a 2-year probation, court services has a 1-year probation. If that 2-year supervision or the 1-year supervision ends, or just bear with my horrible example here, but the one supervision ends, do we just transfer it back to the original supervision entity, or does it stay with the person that took over the first jurisdiction, the first case, I'm sorry. And I think we need to look at it are we just talking about transfers of supervision? Or are we talking more, if rather than having dual supervision entities that a judge has to put it on the other, one or another entity with whoever's being supervised? I think we really got to nail down that portion as well, because I think those are decisions then that come into effect on how we manage our policy and looking at conditions of probation. And and plus looking at another subcommittee is looking at possible earned discharge credit, right? And so if we transfer, say, court services transfers to community corrections, do they do all the earned discharge credit, or does it go back to the original supervision entity to make sure that earned discharge credit is granted through the court? So there are just multiple layers of issues that we look at, but I think we need to just figure out, are we looking at transfers, or are we looking at actual who supervises it at the court level?
Yeah, so Spence, I think that's a really great point. And to kind of take up the first thing you had mentioned, are we really just talking about a courtesy transfer? My sense is no, we're looking at something more formalized than that. But I think the point that you're raising about, if in your example, you've got community corrections for a particular term and court services for a different term and, say a longer term, and, they finish their court services part. If they're being supervised by them, do they stay with them? And so if they did, how would that affect jurisdiction issues? I think that's something that we would really need to look at. If there was a transfer to an agency that had a shorter supervision period, if there was some determination that agency was better situated for this person to supervise them, but the supervision time on that agency ran out, there was still time left over on another agency. If they stayed with, in this example, court services, how would that affect, or in this example, if they stayed with community corrections, how would that affect supervision, or rather jurisdiction on court services? And I don't know the answer to that. Does anybody have a sense on that?
And this is Spence Cohen again. And just to add another layer, I think it also, and we've talked about this previously, if say community corrections isn't involved, but it's a parole case and a court services case, how do we deal with that jurisdictional issue? And I think, I know Secretary Zamuda spoke on this previously. I can't remember. Sorry, Secretary, what your thoughts were about this, but I know this was another issue that we've raised and discussed about the, talking about the jurisdiction between the executive and the judicial branch.
Yeah, this is Jeff Samuda again with Kansas Department of Corrections. So, what might help frame the conversation is a reminder, and I don't know if Stephanie's still with us, a reminder from CSG as to what they were seeing. I mean, it's not as simplistic. I make it overly simplistic in my comment about, hey, let's just find whoever's got them the longest for that continuity, which I believe the continuity helps that person under supervision. It's kind of like me getting passed from one supervisor to another in my work. That doesn't work real well. But maybe it helps us formulate our conversation if we knew what they were seeing, and if you could just restate those for us. And I see Stephanie on there. Could you kind of tell us what you were seeing and what the key issues were?
Yeah, thanks, Secretary Zamuda. This is Stephanie with CSG. So when you have a dual supervision, first, just a reminder to the full subcommittee is that we didn't get a full sense of the dual supervision problem because we didn't have access to court services data. And so we actually couldn't pinpoint the extent of the problem in the state. We knew from looking at parole and, post-release supervision and community corrections that there was potentially an issue in the state, because that 5%, that's a good amount of people that you're having crossed over. And then anecdotally, we were hearing from different districts that they were seeing between court services and community corrections a larger percentage than 5% of people that were on dual supervision. And so some of that data hasn't been made available. We would love to be able to look at that data in more depth. And it sounds like, Shelley, you were, that's what you requested, correct? From the Sentencing Commission. Yeah. So some of the problems that come along with dual supervision, though, I think we've listed them, and correct me if I'm wrong, if this was what you were looking for, Secretary Zamuda, but some of the problems that we see have been listed here, right? So we're seeing an application of resources from both supervision agencies or multiple supervision agencies where there aren't resources to spare. That's going to be a big one for your staff. For the population in general, having multiple sets of conditions, having multiple offices to report to, having multiple different sets of fees and fines to pay, all of those prolong their re-entry back into the community as, unsupervised community members, right? It keeps them under the thumb of their supervision agency longer, especially if we're seeing that supervision agencies aren't able to collaborate on who's to enforcing certain conditions, special conditions, right? So if you're saying that, you know, you're supposed to get 12 months on probation, but after 12 months, I haven't collected any of your fines or fees for court services, and now you've got to spend another 9 to 12 months because you can't pay those fees off right away. You know, we're extending out their supervision time, which is also kind of not what was agreed to by the court.
This is Sheriff Card. I'd like to expand on that because now you've also got the difference of the agencies who will term them unsuccessfully or successfully, but pending the fees, fines and fees being paid, and then they'll turn it over to collections. So you're right. And then I know in our jurisdiction, we've had issues where an agency will say, all right, you have to participate in this program, but it's not ordered by the court. But because there's this little technical thing, or any other programs is deemed necessary by the probation officers or the agency. And that judge that we had, I mean, he was pretty frank. It's like, look, I'm hearing the case, I've read the file, this is what's necessary. So then it was being other heartaches were being pushed on to the clients. So, and unfortunately, the root of some of that evil is money, because it was another way for the probation offices to collect other fees. So
Yeah, Sheriff Carr, that's a, you know, to kind of dovetail off that. This is Stephanie with CSG again. I do want to highlight that there is, in some areas, not in all, no statement can be made as a blanket statement for any state, right? But that there is a different approach to supervision between court services and community corrections, whether that be uniform or not. But in some districts, there's a different approach to supervision. In some areas, it does, there's different enforcement of supervision conditions. And so with community corrections, there may be some, okay, you had a dirty drug test. What are we going to do to make sure that doesn't happen again? This is just an example. This could go in either direction. So I could interchange these supervision agency names. So just to make sure I'm clear. Whereas court services, in that district, it may be that if you have one dirty UA, you are no longer eligible for early discharge. You may be taken right back before the court, whereas that doesn't happen with community corrections. There's a little bit more leeway there. And there's research to support the leeway there, right? So they weren't perfect people going into the system. They're not going to be perfect people on supervision, but we need to figure out where their needs lie in order to respond to those needs, in order to improve their compliance, to get them to a point where they're leaving supervision successfully. But there's different approaches and mentalities to supervision, and that's going to impact the ability to have more support for uniform support for dual supervision across the state to fixing dual supervision. And so that's kind of one of those challenges I would say is something that would be tough for this subcommittee to address, but should be kind of brought before the subcommittee for consideration, that if we don't have a kind of a uniform approach to supervision across agencies, it's going to be a challenge to kind of address this particular topic in general.
So Stephanie, thank you for framing that issue. Let me ask this, because I don't know if it will be possible to create uniformity on policies like that. Is there still a way so that that doesn't become an obstacle to achieve the goal we're looking for? For example, could it simply be a situation where, well, not simply, but could it be a situation where the agency that that basically has been assigned to supervise this person, that basically it's going to be their method of handling something like the dirty UA that just applies, period. And that community corrections would not necessarily be applying the court services standards. I mean, is that something that we're just de facto or by default agreeing to if we have this consolidation?
Yeah, Professor Francis, that's a great question. This is Stephanie again with CSG. And actually, one of the documents I'm waiting back on from BJA is a framework for concurrent supervision and how to go about doing this. So moving from kind of a less formal agreement to a more formal MOU and spelling out what does that mean. So if you're going to take over the supervision responsibilities, what will you also take on as a responsibility to the agency that they're moving from? So if you're moving from court services to community corrections, what is the responsibility or the obligation to court services to make sure that their supervision conditions are met and satisfied under community corrections? And so that would be fee collection, that may be certain reporting to the judge, it may be informing court services of something, but it would need to be a more formal MOU process. And so once I have that back from BJA, I'm happy to send that to Natalie to make sure that's distributed to the full subcommittee. And maybe that's something that we can work from. And it's really just kind of a loose framework with some considerations for folks to take under.
Thank you, Stephanie. So you said something that prompted another question in my mind, which is, if there's going to be an MOU, I mean, will the paperwork involved in multiple MOUs just become staggering and wind up being an impediment of its own? And is there a legislative remedy that could be built in to whatever proposal we make to the commission and the commission makes to the legislature? Or are we in a situation really where we would need to just be doing MOUs going back and forth?
Yeah, Professor Francis, this is Stephanie with CSG again. I think that's a great question. I would actually lean on on our state partners on their kind of thoughts or opinions towards what an MOU would do. I can definitely see that in some districts, especially in Kansas City, Topeka, Wichita, that it could be an impediment where you have more overlap. But in other places, it may not be too much of a big deal. I think it would be how well the MOU could be standardized so that it isn't something that has a lot of adjustment to it for every single individual. But then again, we want it to be individualized. So we're in a catch-22 as always with supervision. So I would definitely lean on our state partners there to kind of answer their thoughts about adding another piece of paperwork to the mix.
So let me throw that out to Spence and Shelley and Secretary Zamuda. What are your thoughts about that?
Well, I realize I'm a community partner, not state partner, but I'll add my 2 cents here. This is Shelley Williams.
And I definitely meant across the state, Shelley, not just state level.
Oh, yeah, no. But I know it would be initiated at the state level and trickle down. I think if it's clearly articulated, whatever criteria is established, whether it's length of supervision, risk level of offense, whatever criteria is put into an MOU, it would just need to be really clear. And of course, we would follow whatever agreement is made at the state level for supervision. I think what we need to just continuously keep in mind is what is best for the success and behavior change aspect of the offender. And so certainly only having to report to one supervision entity would be best. But I mean, we would work with our local courts and local parole folks to make those transfers of dual cases, to a different supervision entity as seamless as possible. I kind of envision it, and I think we've talked about this before. Spence, help me out, but kind of like we do courtesy supervisions now to other jurisdictions, it's a pretty seamless process now, and we have it down after several years, but I kind of envision it working similar to when we're transferring to other jurisdictions, like community corrections to community corrections, of course. So this would be a little bit more detailed, if you will, but certainly a similar process.
So Shelley, let me ask you a question to follow up on that point. From your perspective, would it work better if it is more of a, collaboration between agencies and they're just told, look, work together on this? Or would it be better to have some type of legislative structure that directs how this would happen?
Wow, that's a great question. I don't necessarily know that it needs to be legislatively mandated, although I'm not sure an MOU would capture it. I think if you leave it up to locals, it'll happen in pockets, but there will be a lot of turf and a lot of territorial issues and a lot of just interagency workings that it would not be uniform across the state. It might not even occur in some jurisdictions based on personality. So I do think it's something that would have to be top-down guidance and top-down driven. I don't know if it's at a policy level or if it could occur at an MOU kind of level. I don't know.
Thank
Amy,
you.
do you have any thoughts? This is Sheriff Carr. I just wondered if Amy had any thoughts on this.
I
Amy?
do, Sheriff, but I'm an attorney and I always have an opinion, right? So I get to say that because I'm an attorney. So I agree. If you leave this to local, it could happen in pockets. We could have vastly different, not likely vastly, but could be really different things happening across the state. And we're trying really hard at the judicial branch to standardize as much as we can, recognizing that some things can't be standardized because of local resources. But so a court user or a client has a similar experience in Shawnee County as they do in Finney County, again, local resources understanding. But so I think that it's probably best to have this top down, as Shelley said, if you want that consistency. And it seems, that's a word that I've heard you all say. So, and I can't speak for DOC, but in my conversations with Hope, and that's their desire to have consistency. So I suppose something to consider if this group wants to legislate this to a certain level. We did some of that some of that happened in the juvenile justice world, where DOC and OJ and the court collaborated on certain items like immediate intervention guidelines, graduated responses, those kinds of things. So that's a possible route. I can say that I have a really good working relationship with Hope. So if this group said, hey, we recommend you all collaborate to do this, we would do that. But if you want to have some extra teeth to require that, then there is some kind of general statutory language that you could recommend. It's always a little hinky sometimes to say statutory anything, because you don't know how it's going to end up sometimes.
So Amy, do you have some statutory language in mind?
There were some different, and I'm not going to be able to quote it off the top of my head because I'm not looking at the juvenile justice statute, but there were several instances, and Shelley probably remembers this. There were several instances in the juvenile justice code when Senate Bill 367 was enacted, where DOC and OJA had to collaborate to come up with statewide guidelines. Immediate intervention programs is something that we had to do. That's essentially juvenile diversion. We had to collaborate on graduated responses, which are steps you have to take before you revoke an individual to revoke their probation. I'm trying to think of I think we collaborated on the earned discharge credit thing for juveniles. So there were several examples, and Professor Francis, I can send you those statute numbers if you'd like, so you can see that language.
Great, yeah, if you could do that.
Yeah, I mean, it's always, there always is a little bit of a challenge when you have two different branches of government required to collaborate, because there are certain things that the executive branch can do that the judicial branch can't do, but we already had to navigate that path with juvenile justice. So, and like I said, I have a really good working relationship with many people at the DOC, so I think we could make it happen. Just understanding that it wouldn't necessarily be identical, because there might be some things, like I said, that executive branch can do that judicial branch can't do, and vice versa. So, but that's an option if you wanted to go down the statute route to require that something be created statewide.
Thank you, Amy. And I think it's at least good for us to consider the legislative route. I honestly don't know, what the best path would be, but it does seem that if we want consistency, there has to be something that happens at the state level, and that's part of the challenge. We have about 3 minutes left, and I want to give people an opportunity to talk, but also I feel that at least I have a better idea of what the issues are, but I'm still feeling like I'm spinning my wheels a little bit as to what the next step is. Shelley, you're going to get some data that you've requested and hopefully forward that out. Amy, you're going to send some examples of circumstances where there has been legislation that helped create collaboration. I want to open it up to what's our next step now, because we are, as Sheriff Carr pointed out, we're running down on time now. And I'm not quite sure where to go from here now.
This is Stephanie with CSG. I would really love to see the subcommittee meet more than once a month from here on. If we can meet maybe every 2 to 3 weeks, at least through September, maybe meet the last week of September, and then again a couple of times in October, or at least 3 more times before November, I would say, to make sure that we can get through kind of all of this. Professor Francis, I'd love to work with you on kind of meeting notes, especially once the subcommittee can see that framework. I think that may actually really help move the subcommittee forward in figuring out what are the next steps, both in recommendations for the full commission, in statutory recommendations. So we'll get that framework to you guys as soon as possible. I'll check in with BJA today and see if I can't get that back today to send out today.
Thank you, Stephanie. And so how do folks feel about, another meeting at the end of September, and then maybe, meeting more again, maybe 2 times in October as well? Okay, we've got some thumbs up there, so that's good. So let's go ahead and just take a look at calendar. Would people be able to meet on Monday, September 27 at the noon hour? Seeing some heads nodding, so.
Assistance, and that's a yes for me.
Okay, thank you. So let's say Monday, September 27 at noon. Between now and then, we'll have a little more data available. Stephanie, maybe you and I can communicate a little bit and talk through what some of the options would be for us to explore a little bit more at the next meeting. All right. We are now at 1 o'clock. Before we break, anybody want to add anything, contribute anything else before we take a break until next time?
I will share that data as soon as I hear back from the Sentencing Commission with everybody that was on this call.
Okay, thank you, Shelley. All right. Any other thoughts? Any information for the good of the order? All right, then let's go ahead and adjourn today's meeting. We'll meet next again on Monday, September 27 at noon. All right. Thank you all very much.
Thank you.
Bye.